Good evening. My name is Nuné Alekyan, and I welcome you at the Future Studio discussion platform. This is our live webinar being streamed via Zoom and on 2 Facebook pages. Future Studio, which is a non-for-profit, non-governmental analytical and discussion platform I have an honor to be a co-founder, and I recognize ARTSAKH, a worldwide civil movement I believe to be a worthy cause to join. Our webinar is being translated into Armenian, Russian, and French, and the translation is available via Zoom. This is Artsakh, and my guest today is Mr. Philippe Raffi Kalfayan, Associate Researcher in International Law, University Paris Pantheon Assas. Welcome, Philippe.
Thank you. Welcome.
In fact, this is third webinar under the auspices. This is Artsakh since the beginning of war, which I'm moderating. And this is the first one when I know for sure that while we are on air, our brave men and women are not dying as we speak. To me, this is priceless. And I'll say it once, and there is something I truly believe wholeheartedly, that the battle might be over, but the struggle continues. We're faced with two eternal questions. Who is there to blame and what's to be done? Understandably, who is to blame dominates our thoughts today, wherever we are. And in a lot of ways, it divides our nation, it divides our communities, and even our families. We witness it on the streets of Yerevan, and on the squares of Yerevan today as we speak. I do hope there will be a transparent and just due process to answer these questions. Having said that, Future Studio is not a forum to pass judgments and to point fingers. We're here to think, to connect, to create, and act together. And we have to be smarter than ever, the way we act, create, and think. I have invited Mr. Kalfayan to talk about what's to be done going forward and to help us understand what it all means for us today and in the context of international law and diplomacy. If there are battles worth fighting, these battles should be of our choosing. They should be civilized, not barbaric and archaic warfare leaders of Azerbaijan and Turkey has violently imposed on us. Mr. Kalfayan, in fact, is joining us from Yerevan, the capital of Armenia, and we actually never met. I've been following numerous publications of Mr. Kalfayan in the Mirror Spectator, Boston-based newspaper, and his recent writings on the issue of international recognition of Artsakh and his views on the recently signed trilateral agreement were quite helpful to me in navigating among the avalanche of news articles and disturbing images. So without any further ado, we have a tremendous amount of questions. I didn't expect that many questions coming addressed to you, Philip, ahead of our webinar. I've tried to group them, and I will rephrase them in a way, but I will also use them as we go along. And my first question to you is about the latest trilateral agreement that was signed by the leaders of 3 countries, what we call a ceasefire agreement. And it's still sending shockwaves, as you said rightly in your articles, among Armenians. If, in your professional opinion, and in the context of international law, what is its scope, validity, and short and long-term implications of this agreement for the Armenia and Artsakh? And developing on that, you've said something that I personally could not understand in this article of yours, that you're saying that this document is of a political nature rather than, and could not be, and rather than a legal nature. So if you could explain in the terms that we non-lawyers could understand that. I also had another question coming from the audience. Could that agreement be amended somewhat from the legal perspective?
So thank you for the questions. So this statement, that's the name of the document, has been signed by the head of state of Armenia. And his signature is internationally binding. What is the scope of this document? Basically, you have two elements. First, that is the ceasefire. Actually, it was signed by Armenia precisely to get this ceasefire because we had to spare lives on the ground. The second element are the interim measures. That means the restitution of some territories, the installation of peacekeeping forces, Russian actually, and some humanitarian tasks like restitution of bodies, exchange of prisoners of wars. So the document is more than a ceasefire because it already gives some elements of territory delimitation. Actually, the territory delimitations have been set at the date of the agreement. That means where the troops of each party were standing. So from that situation, we can say that this is a temporary delimitation. That's why President Putin yesterday morning in its declaration mentioned that it is time now to think and to discuss about the final status of Karabakh. This is also the position of France and United States. So that's why I'm saying also the signature of Prime Minister Pashinyan is binding within the meaning of international law. That remains a political document because in order to be legal from the Armenian standpoint, it has to go through the parliament and pass the test of constitutionality. In the Armenian constitution, such a treaty, because the statement is a treaty, such a treaty has to be ratified by the parliament. Otherwise, it is not valid. So that's why I'm making the difference between the political nature and the legal nature of the document. As long as it is not ratified by the Armenian parliament, then it will not be legally binding for Armenians. However, the political reality is, of course, adding some complexity to this. Because Armenia cannot afford at the moment to go back to war. So it has to accept the implementation of what is written in this statement. If he were to decide to not implement it, then the war will resume again, and probably that President Putin, who has been the mediator in this deal, won't be happy. So we have no escape to implement this agreement as it is. But what we have to do now is to go back to the diplomatic channel. And this is precisely what France and the United States, so the two co-chairs of the Minsk group, have asked for. And this is also what President Putin is saying between the lines in its yesterday morning declaration. So the hope now is to go on the diplomatic field and start again a negotiation about the future status of Karabakh, and most probably about the delimitation of territories.
So there was a question about the future of the Minsk group. You partially answered that. Is there anything else that you want to deliberate? Would that group remain the same in your view, the same participants, or is it beneficial in your view from the legal standpoint?
So this is a good question because, as you know, this trilateral agreement has totally annihilated the Minsk format. While this format was recognized internationally by all institutions, even by the negotiating parties, as the unique format for negotiating the settlement of this dispute. Unfortunately, the negotiation didn't achieve successfully, and that's why Azerbaijan, supported by Turkey, decided to go for a non-peaceful process. So there has been a violation of a format, but there has been also a violation of the principles which were agreed so far by all parties. The first of this principle was the non-use of force. The use of force or the threat of using force are prohibited by the United Nations Charter. Secondly, it was also prohibited in the principles agreed by the Minsk group and the negotiating parties. So you see, we have also a violation of the principles. And this is not the only violation. We were also in these principles agreeing on the principle of self-determination of people and territorial integrity. So here, the self-determination of the Karabakh Armenians is absolutely absent from the documents. It's not even mentioned. So that's one point of negotiation for the future. The second point is the territorial integrity, because is Azerbaijan still in a right to claim the respect of its territorial integrity? And we will come to this point later when we will talk about self-determination and secession. The second point is even Armenia has been in some extent, affected in its territorial integrity, because there is, through this agreement, a loss of sovereignty, especially when it relates to the surveillance of corridors on the ground of Armenia, on the land of Armenia proper.
Interesting. It's can I ask you a bit of a provocative question? Do you think the fact that the issue of territorial integrity and the rights of self-determination has been actually left out from this document, do you think that might be the consensus agreement between Mr. Aliyev and Mr. Pashinyan in a way?
Between who? Between Mr.
Between the Armenia and Azerbaijan.
No, I don't know. I was not in the negotiations and the discussions about this agreement, but I cannot imagine that. I want to say, as an international lawyer, that self-determination is one of the peremptory norms of international law. Peremptory means that this is a norm, so a legal norm, which is accepted by the entire international community, and there is no way to derogate to this norm. So that means that the right to self-determination is binding for every state and in every circumstance. So it is absolutely impossible to draft an agreement, a treaty, where such a right is cancelled or just annihilated.
Mm-hmm. Thank you. So let me just kind of try to understand what you're saying. So by starting a military offensive, there has been a certain violations of certain international laws that we could actually bring up in the international courts, just by the fact that the war has started. Do we have a legal ground for that?
So let me, as a preliminary, explain, because this is always confusing for people who are not knowledgeable with international law.
Such as myself.
I didn't mean that, but there are two legal corpus. One is the law regulating the relationship between states. That means this is the law of international responsibility for internationally wrongful acts. The jurisdiction which can listen to such disputes on violations of this kind of law is the International Court of Justice in Den Haag. So this is the UN court. This jurisdiction, so, and in general, the liability of states before this jurisdiction is a kind of civil responsibility. A state is considered as liable if it has violated a legal norm, so international law. So the violation is the way to state to acknowledge a violation. So we don't talk about crimes, we don't talk about other damages, we are talking about violation of a law. This is important to understand because there is no international criminal responsibility for states. It doesn't exist. So I come to the second legal corpus, which is the international criminal liability. The criminal liability is only and purely individual. It's against individuals. So that's the case in every single country in the world. That's the basis of criminal law. And this is also the case in international criminal law since the ICC, so the International Criminal Court in Den Haag, which has been operating since 2002, tries individuals for crimes of genocide, for crimes against humanity, for very serious crimes of war, and for crime against of aggression. So you see, we have to make the difference between legal proceedings against a state and legal proceeding against an individual. So what do we have here? What do we want to pursue as proceedings? And who can proceed? Armenia or the Republic of Artsakh? So this is a key question. So far, Armenia has never recognized Artsakh. They have always considered that Artsakh is an independent state. So that becomes quite tricky, because how come Armenia will start a legal proceeding against Azerbaijan based on certain conventions? To be frank with you, the European Court of Human Rights some years ago, when they have made a judgment in a case called Shiragov against Armenia, Shiragov and other people were Yazidi from Lachin corridor, so Azerbaijani citizens who have been forced to leave their residences, houses, lands because of the war and exchanges of territories. And during this, in this judgment, the European Court has decided that Armenia was in effective control of the territory, and that the Republic of Karabakh was not totally independent and was not viable without the support of Armenia. So that was a precedent, but Armenia didn't change its position since then. Mm-hmm. So that creates some problems, some obstacles. So Armenia can, in fact, sue Azerbaijan at the ICJ based on some conventions. For an example, it can sue it for because Azerbaijan has violated the convention of recruitment of mercenaries. Azerbaijan is party to this convention. So in order to be able to do that, Armenia should be a party to this convention. So very hastily, Armenian parliament has ratified this convention on the 27th of October. But it will take time before the entry into force, because there is 1 month of delay between the registry at the UN Treaty Office and the entry into force for Armenia. And then you have some arbitration clauses, which is another delay of 4 to 6 months. Third, the convention is not retroactive. So that means that at the time the convention will enter into force, since the war today is stopped, then it will be very difficult to argue on new cases. Secondly, you have to understand that for every convention that you are using for an interstate claim at the ICJ, the other party, so the other state, is able to make counterclaims. So in the case of mercenaries, we can avoid this. In the case of other conventions, like for an example, using the Convention on the Elimination of Racial Discrimination, or the Convention on the Financing of for Terrorist Acts, Azerbaijan has the possibility to make counterclaims. And that means that every single convention that you may use for a claim before the ICJ has to go through a risk assessment. So to see whether we are in fact in a position to win or to fail because of counterclaims. Everybody should be conscious that every single claim is 6, 7, 8 years of procedure. And each procedure in the length, I mean, we are talking of millions of dollars.
We'll get to that. This is one of the last questions for you.
So here I have just talked about the interstate claims. There are also some other interstate claims possible through the European Court of Human Rights. And actually, the agent of the government of Armenia has already initiated some claims at the European Court of Human Rights, especially on the ill treatment of a prisoner of wars or the beheading of another. But this is not the same magnitude as an interstate claim before the ICT. It's totally different. Now there is the other group of, if you allow me, what every Armenian has in mind, which is the criminal responsibility. So here, this is even more difficult because neither Armenia nor Azerbaijan are members of, are party to the Treaty of Rome, which is the treaty which has created the International Criminal Court. So that's very difficult for each of the country to invoke the Treaty of Rome to bring a criminal proceeding against President Aliyev or army commanders in Azerbaijan. That's first. Secondly, you need to have a very strong and very reliable proofs when you go into such criminal cases. If not, the prosecutor will not find your claim admissible. And there are some other alternatives. And as you have probably seen, one Armenian lawyer has instituted a claim in the District Court of Columbia in the US. So the plaintiffs are two Karabakh citizens, Armenian citizens, plus the Republic of Karabakh against a US company which is providing some components of UAVs. So the famous drones, what we call unnamed aerial vehicles. So there are plenty of proceedings that can be pursued, but here I would like to address every Armenian, every lawyer in the world, that it is very important that the strategy is coordinated, because we may end up with counterproductive results. For an example, so this claim, this complaint in the US against the US company is made in the name of a Republic of Artsakh. This republic is recognized by nobody, no state. Even Armenia didn't recognize this republic. So there is a risk here that the US court makes a decision recognizing that Republic of Karabakh is not a state. And that may hinder other processes. And if it doesn't hinder other processes, at least it will give one argument to Azerbaijan. So that's why I'm advocating for a coordination of all legal actions and proceedings, and in a I mean, in a single place. And of course, it has to be Armenia. And in order to not make mistake about this.
Thank you very much. We have a whole body of questions related to the international recognition of Artsakh. Let me start with a very simple one. At the same time, I think it's a very, very complicated one. We know, from real life, that the fact that the state is recognized does not make the state immune to repeated military aggression. In your professional view, why is it important for the Republic of Artsakh to be recognized by other countries? What are the tools that the recognized state have that unrecognized doesn't? This is a basic, sorry for a very trivial question, but I think it's worth spending a bit of time so we understand how important and why is it so important for Artsakh to be recognized going forward.
So as you know, the Republic of Artsakh declared itself independent after a referendum in 1991. It was a legal procedure. However, Azerbaijan did not recognize that. The Minsk process didn't recognize that. And actually, no state in the world did recognize this independence. In reality, as the International Court of Justice judged not judged, but said in its advisory opinion on the Declaration of Independence of Kosovo, this was an advisory opinion from the ICJ. It was not a judgment. So it is said very clearly in this advisory opinion that a state, a state or a territory can declare itself independent freely. It is a matter of fact. It is not provided by international law. It's not prohibited. So far, so good. Means Karabakh is not in violation of international law to declare itself independent. So here comes the problem of recognition. So this is a purely political and diplomatic process. First of all, Karabakh has to demonstrate that it is a state. What are the three attributes of a state? It has to concern a certain population which lives in a defined territory, and third, which can prove that it is sovereign, that it does not depend on external forces. So these three attributes are very important. So that means that in order to be recognized as a state, you need to have these three attributes. So far, as I told you, the European Court didn't decide in favor of this statehood. Of course, Azerbaijan denies it. And they have made draft a lot of legal opinions from prominent lawyers, so to support their allegation. And in reality, the fact that Karabakh is recognized or not will depend mainly on the number of states which will recognize it. Because if the number of states gains the majority of the General Assembly of the UN, then at this time, Artsakh may be able to apply for membership at the UN, and then be protected by the UN Charter of Nations. To some extent, the recognition by some states, depending which states recognize it, but imagine that some major states, powerful states recognize it, then that will enable those states to provide some protection to the Republic of Artsakh. So it will be a bilateral protection, but still very important for the security and viability of this country. I'm going to give you one example, which is quite famous in the Armenian circuits. The last 2 years, the Ministry of Interior of Domestic Affairs from France made cancel some friendship agreements signed between some French municipalities and the municipalities of Artsakh, because it was illegal to sign such cooperation and friendship agreements with municipalities located in a country which is not recognized. So imagine that Artsakh is recognized, then nobody will be able to prevent those countries, those self-government bodies to sign agreements and start cooperation with the Republic of Artsakh.
Yep.
That's quite important.
It is very important, yes, indeed. Am I right in my understanding that for at least last 2-3 decades, we've been somehow locked into this Azeri-dominated discourse or standoff between these two notions? One is the right of nation for self-determination and the territorial integrity. There is also a lot of basis to say that Artsakh was never part of Republic of Azerbaijan the way we know it today. But that kind of discourse has been very well effectively attacked by the Azeri side for years. But recently, I've personally came across another notion, which is called remedial secession. How does all these things fit together? What would be, if you could just give us your understanding, what is the basic basis for the international recognition of Artsakh, given that two kind of contradictory notions of the self-determination of the nation and the territorial integrity, and where does remedial secession or secession on the humanitarian grounds come from and come in, and what are the precedents that we could evoke to straighten out our case?
Okay. So first of all, this is pitiful that Armenia has locked itself into the principles defined by the Minsk group. Okay. Because they could have challenged these principles from the beginning. Of course, there is always rapport de force, a balance of powers when we talk about this. But they could have challenged these principles. But the Armenian diplomacy has always considered that the process should remain political and not go on the legal field. And this is one of the major failures of the Armenian diplomacy. Because after 25 years, so Azerbaijan has shown that, okay, you don't want to apply, you don't want to implement what we have negotiated so far, then we go for war. And so that's my first remark about this process. So we could have, in fact, challenged this opposition between the self-determination and the territorial integrity issue, but we didn't do it. So now let me explain very simply. The self-determination in international law is foreseen and provided by international law as a process purely internal to establish states. So this is considered as a democratic process.
Mm-hmm.
That means that a people or minority which lives in a certain territory in the concerned state can ask for self-determination, but in other words, it is a high autonomy. It's not independence. Or it may be independence, but in a federal state, okay? But this is purely internal to the state. There is one exception which is provided by international law that concerns the decolonization process. All the people which were colonized so have automatic right to self-determination, and they even have a right to secession by law. This is the only case which is provided by law. So now what happened? What happens to the cases where you have a territory which is harassed, persecuted, oppressed by the state, by the majority? So so to some extent the state does not care about the rights of this minority or these people. So here may enter into question what we call the external self-determination. So in other words, unilateral self-determination. This external self-determination, also called secession, is not provided by international law. There is no written law about this because all states are against opening the Pandora box. But it's not prohibited either. So when the international community, and especially some specific states, had to face with such request for secession, it happened that they have been obliged to define some criteria. So just to give you some examples, Catalonia has decided to secede from Spain through a referendum. But the Supreme Court of Spain decided that it was not applicable. But what Canada did before Spain about Quebec was more significant. And actually, the Supreme Court of Canada has established the three criteria for giving right to secession. In the case of Quebec, they have rejected the outcome of the referendum, so providing independence to Quebec, because it has been established by the Supreme Court of Canada that, first of all, so there was no failure to respect the principle of representativeness by Canada of the right of Quebec people. Okay, so this is the first criteria. The host state the established state has to respect the representativeness of the whole peoples of the territory. The second criteria is the violation of and very blatant violation of fundamental human rights. And here, the Supreme Court of Canada and also the doctrine of international lawyer is very explicit. The fundamental human rights law violation, which may give right to secession, are threats to the physical integrity of people, of persons, of individuals. In other words, a threat of extermination or forced displacement or forced deportation. So that's the second criteria. And the third one is the impossibility of a peaceful solution within the existing state structure. So if we want to claim a right to secession for Artsakh Armenians, then we have to meet with these three criteria. Did we meet them today? Most probably. But we have now to go through a very serious and fastidious process, because we have to prove that today the three criteria are fulfilled in the case of Artsakh.
But what would be the court? I mean, if Azerbaijani courts in 1990s was anything like Canadian courts, I will think that would be a viable course of action. But we know.
No. So in that case, in fact, it will go before the ICJ. So Artsakh Republic will have to make a claim, but it has to be represented by another state, because Artsakh Republic cannot go to ICJ. They are not member of UN. They are not member of UN.
Recognize Artsakh or any other? Would that require Armenia or any other state represent Artsakh and then act on behalf of Artsakh?
Exactly.
So the moment a given country recognizes Artsakh, we can bring our case to the court.
Artsakh can bring the case to the court, right. Yes.
Right, thank you. That makes sense. I'm just checking if there are a lot of questions, but how about but that would that mean that we, in a way, agree with the fact that Artsakh is a part of Azerbaijan?
So this is, in fact, the main issue that Armenians, when I say Armenians, I'm talking about Artsakh, Republic of Armenia, and diaspora, have to fix. Because today, this is totally uncertain. Republic of Artsakh has always said, we are independent, we are a state. So we request from international community the recognition of our state. Armenia today is saying Artsakh has the right to secession, remedial cessation, because of criteria that I have just mentioned. So when you claim that Artsakh has the right to remedial cessation, so you implicitly mean that Artsakh is not independent today. So you see the confusion here, and abroad in the diaspora. So you have also confusion, because you have some people So going on in the direction of secession, and some others going into the recognition of Artsakh independence. So this is what we have to fix in a very elaborated manner. So a global strategy between the three entities.
Mm-hmm.
And then we have to get a coordination center for all these actions.
Philippe, I have a whole kind of body of questions relating to war crimes, violations, rights of refugees. We have quite a lot of questions on what refugees should do today. I have to apologize. I don't think we will be able to address them today. I have to apologize to the audience, but I promise I'll do my best to have another webinar dealing precisely with the issues and probably bringing local Armenian lawyers to help displaced people from Artsakh to have their answers to the numerous questions that they have. Let me move to the last question, which you've already started elaborating about. When you and I spoke, you kind of dropped a phrase, a global legal package. And I immediately picked it up because it very much resonated to the notion that Ruben Vardanyan and I wrote about in the discussion paper at the Crossroads of the possibility of public-private or private-public partnership when a certain legal aspects of international law are being handled by a body of international lawyers that are working together, but in a close collaboration with the Ministry of Foreign Affairs, with governmental bodies. Could you kind of give us your perspective? How could this all be done so we don't end up in the situation we were in basically after the genocide, when we were not represented in courts?
Yeah, this is a painful, in fact, subject for me.
Yes.
Because I have been advocating since so many years for having already such a strategy about the reparations for consecutive to the genocide. And nothing happened because there is no such center. So here, what of course I do believe that in the case of Armenia, it is paramount that we go in such a direction, because Armenia has not the budget to go for such heavy and long legal proceedings by itself. Because here we are not talking about $10,000s of dollars, we are talking about millions of dollars each year. Second, Armenia has not the human resources, neither legal nor even for fact-finding. So this is a very heavy work. Usually, some big law firms are even helping on this aspect, or on the ground materials. So collecting the proofs, collecting the testimonies, and then orchestrate the structuring, the ensemble of proofs. And then you have the lawyers who will represent the state before the ICJ or before other courts. And this is another layer of intervention. So And as I have already told you in the introduction, there are so many procedures. You have interstate, you have individual criminal liabilities, you have human rights jurisdiction. So all these direction and legal avenues need a lot of human resources and a lot of funding. Secondly, and you will see that how prepared was Azerbaijan. They get prepared to this war since 25 years or 20 years, let's say. They have regularly registered at the United Nations Security Council office legal opinions, very well elaborated legal opinions. So contesting, so opposing the occupation, opposing the economic activities performed on the territory of Artsakh, so contesting the self-determination right of Artsakh Armenians, and so they have been very active in this legal field. And just the last 2 days, a famous European journal of international law has published 2 articles against Armenia and Artsakh. So obviously, the articles have been sponsored by Azerbaijan, and we were not prepared.
But we must have excellent lawyers around the world.
Yeah, but you must be prepared to such things, and you see, and the articles have been published yesterday and the day before, and it will take a month or 2 to get responses, because you can challenge these articles. I mean, they are not the Bible. They are just legal opinions. So you have to challenge the legal opinions ordered by Azerbaijan. So that means that you need to select the right people, right lawyers, prominent lawyers, and so that they can challenge the opinions. The third aspect is PR and lobbying. That also requires a lot of money and competencies. And fourth, this is the resource and task sharing. We have a lot of skills in the diaspora. We have also talented people in Armenia, but there is no strategy, there is no coordination, then all these skills and talents are lost. They don't do anything because they are isolated. So this is my last point. I mean, the coordination is key. And coordination is not only elaborating on strategy. This is also coordinating the funding, the resource sharing, the task sharing.
Philippe, should we wait for the government to pull us all together? Or can we do it on our own accord and offer certain terms of cooperation to the government of Armenia and Artsakh? I'm struggling with that question all the time, not on, necessarily with the legal field, with development projects, with humanitarian aid projects. Who should be the driver? Should we sit around and wait for the government to formulate and call us all in, the lawyers in Armenia, lawyers in Artsakh, lawyers abroad, and say, okay, guys, let's sit down and talk about it? Or should we get together and formulate some kind of agenda and put forward to the government?
I have no hesitation. I'm in favor of a second option. So we need to engage ourselves without waiting for a government or a viable Ministry of Foreign Affairs. We have just to make sure that they will not oppose our actions in the field. Yes, we have to move forward and not wait for God to tell us, yeah, you can do it. I have already experienced this in a narrow aspect of genocide reparations successfully. And I'm sure that if we can gather goodwills, skills, and dedicated people in one private initiative, we can reach that goal, also some success. And this is what we have to do, because don't expect Armenia in the current situation to be the driver on such initiatives.
Philippe, we need good news. Tell us about the case that you won.
Well, so I have tried to find for many years what could be the right approach to push Turkey to admit that in reality they are not willing to address the Armenian genocide, because officially they are always saying, well, we have suggested to Armenia to come and discuss, to study with us the facts of a genocide. And this is always their excuse to not engage in another aspect of a case. So I have found with a team of prominent international lawyers that I have gathered a breach, and I decided to use the International Convention on Enforced Disappearances. This convention has been established in 2005, and so the particularity of this convention is to say that as long as the fate of a disappeared person is not established, then there is a continuity of a crime. So there is a continuous crime. This convention does not fix limits in the time. But of course, opponents are trying to explain that the convention cannot apply to cases before 1945 because of the UN system. But there has been a precedent. For example, families of the disappeared people during the Spain Civil War, so 1936, 1937, so successfully got application of this convention.
So that would apply to others as well.
It created a precedent. And so I just used that bridge. And after many years of discreet lobbying, it was very discreet. I have endorse the allegation by some prominent Armenian institutions, so representative of the Armenian people worldwide. And we have registered the allegation of enforced disappearances. So for about 600,000 people for which we never knew what happened to them. They have been deported, but we have never been able to establish their fate. Have they been killed? Have they been have people have been adopted and converted to Turkish families and Islam? Have they have they disappeared in the desert or anywhere else? The convention obliges the country to make investigation about the fate of disappeared people. So Turkey is not party to the convention, but there is a international declaration for the same purpose. So I use this declaration, which provides some kind of obligation, not binding, but that provides some obligation. And in fact, different UN special procedures have questioned in March 2019 Turkey about this. Said, well, we have received such allegation, so we want to know what has been the fate of these Armenians, which have been deported forcibly, and whether you have opened an investigation, and why have you established some laws in Turkey to prohibit the discussion about these issues. So the tactics was in fact to establish a link between what is prohibited today and what happened yesterday, just to prove the continuity of a crime.
Thank you very much. As my last closing remarks, I thank you wholeheartedly for being with us, and I thank you for being in Armenia. And I know you haven't been idle while you've been in Armenia for last, how many weeks? It sounds like that we simply don't have to be just smart. We have to be very shrewd to win this particular battle on the field of international law and diplomacy. And we have all the capabilities if we try to bridge our differences. Because there's a handful of very good international lawyers out there of Armenian descent and in Armenia. And by joining their efforts together, I think people of Artsakh will feel that their backs are being covered. And I think that is so important that, people who lost everything today, they know that there's someone there who is defending them and thinking about them. So we've got so many battles. I think we should be in the position to choose the right battles to fight. And we have very difficult situation with displaced people, with the wounded servicemen and servicewomen coming back. We need to rebuild. We've got COVID raging. We've got winter approaching. And these are all, to me, the battles that are worth fighting. Together with, and being on the legal front and a diplomacy is one of the major battles. So we've got a lot of battles ahead of us. And I think these are the constructive battles. And if we win these battles, no one could drag us into this barbaric and anarchic means of fighting the actual war. And I thank you everyone for being with us. I have two closing remarks, if I may. Aurora recently announced a series of humanitarian initiatives to support Artsakhi Armenians. Tune in, join in, help out. There will be updates coming daily on the website and on the Facebook and Instagram pages of Aurora Humanitarian Movement. Join me in the civil movement that has been recently launched. Get your Artsakhian Narod, as the one I'm wearing today. And basically that signifies that the struggle is on and there are a lot of battles that are worth fighting. Thank you very much for everyone. And thank you very much, Philippe, and your colleagues.
My pleasure.
Goodbye.
Goodbye.